the Democratic Alliance, and by my learned friend's client, the Economic Freedom Fighters. Lady, may I get straight to the heart of what appears to be the objection to the DA and the EFF's application for leave to intervene. We see in Mr. Molefe's affidavits, and also in the heads produced by his learned counsel, their essential contention appears to be this: that Mr. Molefe has brought an application in this court to challenge what he believes is an unlawful and unfair dismissal by ESCOT. He says that his claim arises from a breach of contract. It is a contractual claim between parties, and it is a private matter. It is a personal matter, as he puts it in his papers. It's a personal contractual matter between the parties to the contract, and political parties such as the Democratic Alliance and the EFF have no business being heard in this court. They have no interest in the matter, and they have no right to be heard because it's a personal matter. Lady, even if there were no High Court application pending, political parties such as our client, the Democratic Alliance, indeed have an interest in matters such as this. Quite apart from their interest, and we'll get to the law on that in a moment, they, in any event, both of the political parties that are represented before your ladyship today have brought separate applications that have been consolidated in the High Court, in the Gauteng High Court sitting in Pretoria. Part A of that application, your ladyship will see, has been settled, in that there is an interim order that was made by agreement that Mr. Molefe, Mr. Brian Molefe, will not return to perform his duties, at least pending the outcome of this application. And we have reserved our rights there, even if he were to succeed in this application, to go back to the High Court for further Part A relief. What remains pending before the High Court too, my lady, is Part B of that application, in which both the DA and the EFF seek to review the decision to reinstate Mr. Molefe earlier this year. Those applications by the DA and the EFF were brought before Mr. Molefe's recent removal from office. We, of course, wish to argue in this court, if we're given leave to intervene, that he was never reinstated validly. Now, my lady, may we get to the first crucial point, which is the interest of political parties in matters such as this. And your ladyship will have seen that in our heads of argument, we have cited a case which, as it happens, was brought by the DA against President Zuma and the acting National Director of Public Prosecutions, in which the DA sought to challenge the decision of the head of prosecutions to drop charges, the more than 700 charges that were originally brought against our president. And in the High Court, in that matter, in a preliminary hearing, the High Court ruled in favor of the President and the acting NDPP on the basis that it was held that the DA had no standing in a matter such as that to review a decision of the acting NDPP. And lady, there the argument was that this was a matter purely between a person facing potential criminal charges in the person of the President and the prosecuting authority. It was a private matter between the accused or potentially accused party and the prosecuting authority. that argument was upheld in the High Court, but roundly rejected by the Supreme Court of Appeal. Now, we have quoted an extract from that judgment, but I would like to quote slightly wider from that judgment. It's the matter of Democratic Alliance and others versus Acting National Director of Public Prosecution and others, 2012 3 SA 486 SCA. And the heading of locus standi appears above paragraph 38, and the passage runs from paragraph 38 to 47. What I would like to quote from, if I may, is this paragraph from paragraph 43. As pointed out earlier in this judgment, the DA is a registered political party active in the national parliament. Its federal constitution sets out its political vision. This is the DA's constitution. A vision of a prosperous, open opportunity society that is uniquely South African, in which every person is free, secure and equal before the law. The DA's constitution recognizes that South Africa's constitution is the only foundation on which an open opportunity society can be built, because it recognizes that every person is equal in dignity and worth and guarantees the freedom of each individual. The rights enshrined in the constitution must be defended and promoted in order to protect the people of South Africa from the concentration and abuse of power. So they're referring to the South African Constitution embodying these rights and protections, including the right of the people to be protected from an abuse of power. And then the learned Judge Nafsa, writing for the full court, continued in paragraph 44. It was accepted on behalf of the third respondent that all political parties participating in the national parliament can be taken to subscribe to constitutional principles. So that's national constitutional principles. Section 48 of the Constitution provides that before members of the National Assembly begin to perform their functions, they must swear or affirm faithfulness to the Republic and obedience to the Constitution. If I may interpose, this very point was pointed out by the learned Chief Justice in the recent judgment in the matter that was decided very recently to do with the secret ballot vote. And then His Lordship, Mr. Justice Navta, continues, all political parties participating in Parliament must necessarily have an interest in ensuring that public power is exercised in accordance with constitutional and legal prescripts, and that the rule of law is upheld. They represent, these political parties, they represent constituents that collectively make up the electorate. They effectively represent the public in Parliament. It is in the public interest and of direct concern to public parties participating in Parliament that an institution such as the National Prosecuting Authority acts in accordance with constitutional and legal prescripts. It can hardly be argued that citizenry in general would be concerned to ensure that there was no favoritism in decisions relating to prosecutions. Few members of political parties or members of the public have the ability, resources or inclination to bring a review application of the kind under discussion. Now, the judgment then continues to apply this principle to the particular facts of that case, and to show why it is recognized in our law that a party such as a political party, particularly one that is represented in Parliament, that is representing a constituency, and which subscribes to constitutional principles, has a direct interest in holding branches of government, organs of state, to account to ensure that they are free from abuse of power and that they comply with constitutional and legal prescripts. Now, milady, that approach of the Supreme Court of Appeal, we submit, is a recognizes a powerful principle relating to legal standing in litigation. And it shows how far our courts and our law have moved away from the traditional approach to legal standing in the past. Of course, where, for example, Pick n Pay fires an employee, it would be difficult for a political party such as the DA to come along and say, well, it has an interest in Pick n Pay acting fairly or lawfully, because that is indeed a private relationship between Pick n Pay or any other private sector employer and its employee. And it raises the question of how an employee such as Mr. Molefe can seriously come before this court and say that this court should not recognize the legal standing of political parties such as the DA and the EFF because his employment relationship is with ESCOM, and that is a private, personal matter arising from contract and nothing more. It concerns an organ of state spending public money, exercising public power, providing public services. So when Mr. Molefe supposedly retired, as he puts it, or went on early retirement, as he puts it, to the complete surprise of the minister who is actually representing his employer, which is the shareholder in ESCOM, which is the government, which means the nation, when he takes early retirement in terms of an agreement concluded with the board, which the minister knew nothing about, and received something like 30 million rand for his trouble of spending just a couple of years in office as group chief executive, that is not a purely personal matter. It is not a private matter. It is not a purely contractual matter. There may be elements of contract law, there may be elements of employment law that come into it, but the parties that have an interest in such a matter, particularly where public funds are expended in such a huge amount, what the EFF's heads quite rightly describe as an obscene amount, the public have an interest. And as the SCA and as acting NDPP judgment points out, individual citizens who may also have an interest don't have the resources to come and litigate about this sort of thing. They expect their parties, such as the DA, to do that for them and to hold government to account when it abuses power and misuses public money. Milady, I made the submission earlier that even if it were not for the High Court application, the DA and the EFF would indeed have the necessary legal standing by virtue of this very principle that was established and confirmed by the SCA in the Acting National Director of Public Prosecutions matter. And may we add, Milady, that it's not surprising that we have a huge amount of litigation that has been conducted in our various courts, very seldom in this court admittedly, but frequently in the High Court, and of course in the SCA, and of course in the Constitutional Court, where political parties bring cases. And their locus standi is not rejected. They're not kicked out of the hearing. They are recognized as being some of the spokespeople of South African people. So you have political parties that have brought cases, the DA, the EFF, the UDM recently. You have civil society organizations such as Freedom Under Law, Justice Alliance, OUTA in relation to the e-toll litigation. We've seen countless examples of this in over some years under our current constitutional dispensation. Now, in a matter where we have huge issues of public accountability, of allegations of abuse of power, of contracts being signed by the chief executive of ESCOM under a cloud of allegations and observations made by the public protector, who has recommended that a judicial commission of inquiry be appointed to investigate those allegations, which include allegations concerning how ESCOM has filled its public role and spent public money, extremely serious allegations. This is a matter which preeminently deserves the attention of the courts and deserves recognition of the vital interest that political parties and other civil society groups wish to bring through the court mechanisms. Now, one other troubling phrase is used a couple of times in the papers, both the affidavits and the heads of argument for Mr. Molefe. And that is that not only is the matter a personal matter between Mr. Molefe and ESCOM, but the DA and the EFF are simply trying to turn this into a political battleground. They're fighting their own political battles, and therefore the court should somehow disentitle them from being heard. We submit that the participation of political parties is not confined to standing for election to Parliament or to ward positions on municipalities or on provincial councils, assemblies. We submit that political parties indeed have a wider interest in that, and in the particular passage that I quoted from NAVSA JA's judgment in the Acting National Director of Public Prosecutions matter a moment ago, that is confirmed in our law. Now, my lady, apart from the interest of a political party to get involved in a matter such as this, we of course have the added feature of this case that there is currently pending the High Court application. Now, I pointed out, my lady, that although the EFF also has applied for additional relief, the main relief that is in issue there, and it is the focal point of the DA's application before the High Court, is to review and set aside the purported reinstatement of Mr. Molefe. Now, you will recall, my lady, from the papers, and of course this was well publicized in the media, that Mr. Molefe announced to the world in a press statement, which was followed immediately by ESCOM's media statement, which was followed immediately by the Minister Lynn Brown's media statement. He announced to the world that he was the subject of allegations in the Public Protector's report, the State of Capture report, and that he believed that it was in the interests of good corporate governance, while denying any wrongdoing on his own part. He believed that it was in the interests of good corporate governance that he should no longer carry out the duties of chief executive, and his employment was therefore terminated. And ESCOM confirmed its acceptance of this position as being in the interests of good corporate governance, and so too did the Minister. Now, the Minister has explained in her affidavit in this matter, my lady, and indeed in the High Court application too, that she at the time understood this to mean that Mr. Molefe was resigning. She only discovered much later, in fact, as a result of the High Court litigation that was brought by the DA and the EFF, that there was in fact an agreement concluded between Mr. Molefe and the board without her knowledge. And she expresses considerable grave concern that that happened without her knowledge. And she's entitled to feel that, milady, because she is the minister. She is the shareholder on behalf of the government, because Eskom is fully owned by the government. And only she, in terms of the memorandum of incorporation that has been reproduced in the papers before your ladyship, and is referred to in the heads of argument when we deal with the merits, she is the only person who can appoint or remove from office the chief executive of Eskom. And so she understood, in fact she had had a meeting with Mr. Molefe, she says, some days before this so-called early retirement agreement was concluded between him and the board. She had a meeting with Mr. Molefe. He mentioned nothing about early retirement. He mentioned nothing about 30 million rand as the juicy golden handshake that he would be receiving. He simply said to the minister, so she says under oath, that at this meeting he said there was now a cloud over him arising from the state of capture report. While he denied the allegations of impropriety, he felt it was in the best interests of corporate governance that he stand down and leave Eskom, and she accepted that. Then he goes off to Parliament and he's sworn in as a member of Parliament. Now you'll have seen in the papers, my lady, that in terms of the Constitution, no person who is employed in an organ of state, such as Eskom, can at the same time be sitting as a member of Parliament. Our learned friend Mr. Lukatobi's heads of argument deal with that in some detail. So he goes off and he gets sworn in somewhat controversially as an MP. He cannot hold at the same time the position of chief executive. No problem, thinks the minister, because he's left, he's resigned from Eskom. Then it comes out through leaks, etc., that, well, he's in fact going to get 30 million rand as a golden handshake, because he's now taken early retirement at the grand old age of 49. And then it turns out that if he'd bothered to look at the rules of the pension fund, and if Dr. Ben Ngubane and those in his board and those who advised the board had bothered to look at the rules of the pension fund, they would have seen that the rules preclude anybody below the age of 55 from taking early retirement. So what do they then do? They say, oh, well, he can't get the 30 million. So now we're going to reinstate him. So says the board and Mr. Molefe, and for a time with the approval of the minister. Of course, she's explained she was at that stage labouring under the impression that he had simply resigned before. Now the reinstatement then, he relied on to leave Parliament, to come back to Eskom. He doesn't get the 30 million, so he's going to come back as chief executive. That is a matter of huge concern. In particular, what has happened to the concern about what is in the interests of good corporate governance, which was the very reason that he used to his credit when he left the service of Eskom. He said, that's why I can't stay on at Eskom. And he said that to the minister, and she accepted that. He said that to the world in his media statements. So they try and reinstate him. Now it is the reinstatement agreement that the DA and the EFF challenge in their respective High Court applications. And their contention in the High Court is this, that Mr. Molefe resigned the end of 2016. He could not now be reinstated validly. It is subject to review on a number of grounds, one of which is fundamental irrationality. The minister seeks to justify it by saying, she sought to justify it at that time by saying, well, we needed to get the best situation from a fiscal point of view to the benefit of South Africa. And what is before the High Court is our argument that is irrational. If he had in fact resigned, and she's now gone on oath to say that in her view he did resign and she was his employer, then why did she need to reinstate him to save 30 million rand, which wasn't legally payable anyway? So the High Court is seized with that matter. Interestingly, Mr. Molefe has not raised in his papers in that matter any challenge to the DA's legal standing, or for that matter the EFF's legal standing, and in fact reached a settlement agreement with the DA and the EFF and the Minister and ESCOM in Part A of the High Court application, in terms of which he would not continue to work at ESCOM pending the outcome, at least of the Labour Court application. Now, lady, what Mr. Molefe will be seeking from you on Thursday, when the merits of this matter come to be argued, what he will seek from you is a court order to the effect that his termination, and his termination of course means by way of the latest resolution taken by the ESCOM board to rescind its earlier decision to reinstate him. Now, lady, what he says in the founding affidavit in this matter is particularly significant, because it highlights, even before we got the opportunity to do so, on his own version, he highlights the link between the Labour Court application and the High Court application. May I take your ladyship to the papers? And at page 6 is an early part of his affidavit where, under the heading Nature and Purpose of the Application, he explains what the application now brought before this court is about. He deals in paragraph 7 and 8 with the fact that his employment has been terminated. He says it was unlawful. And then he says this in paragraph 9. My dismissal comes no more than one court day before the hearing of an urgent application brought by the Democratic Alliance in the Gauteng division of the High Court under case number XYZ against the Minister, ESCOM and myself. This application, that's the High Court application, will be heard simultaneously with an application brought by the EFF sought under case number XYZ. The relief sought by the respective political parties overlaps to a considerable extent, and my answering affidavits adopt an identical stance. That's in the High Court. For practical purposes, I will deal with the DA application, the papers filed in response. And then he says in paragraph 10, in Part A of its notice of motion, that's in the High Court, the DA seeks interim relief interdicting me from performing any duties and or functions, or from receiving any benefits or entitlements deriving from or associated with the position of the Group Chief Executive at ESCOM, pending the determination of the relief sought in Part B of the Notice of Motion. In Part B, the DA seeks an order reviewing and setting aside the Minister's decision to appoint and or reinstate me as the Group Chief Executive. And then he attaches various papers from the High Court. Part A of the relief is set down for hearing on Tuesday, 6 June. By virtue of ESCOM effectively having dismissed me on Friday, 2 June, I face the real prospect that unless my dismissal is declared unlawful and set aside, that's by this court, before Tuesday, 6th of June 2017, the relief sought in Part A, that's, if I can interpose, of the High Court notice of motion, will be made nugatory, with the same consequence following for Part B of the relief. As a result, and unless my dismissal is urgently reversed, the whole application, that's the application, the two applications in the High Court, one by the DA and the other by the EFF, would have been rendered academic. This is highly prejudicial to me in that not only am I the victim of an unlawful dismissal, but my right to oppose the relief sought by the DA will have become sterilized. This notwithstanding that I've chosen to oppose the application through the filing of a comprehensive answering affidavit. So then he sets out what order he seeks from this court, and he specifically says, in the paragraphs I've just quoted from, the reason why I have to be in the Labour Court, and to do so very urgently, is that the High Court application would otherwise be rendered academic. This shows, we submit, my lady, that there is a clear and obvious link on his own version between the Labour Court matter and the High Court matters. And then, my lady, at page 31, he deals with urgency. And under the heading urgency, page 31, paragraph 77, he again refers to the High Court application being set down for hearing within a day or two. And then he says, halfway down paragraph 77, absent an order from this court, that's the Labour Court, declaring my dismissal to have been unlawful and void ab initio, considerable prejudice will be caused to me in that it will render the application brought by the DA academic to my ultimate disadvantage. And then the same theme is pursued through the later paragraphs. Page 32, paragraph 78, the third last line. Unless my dismissal is declared unlawful and void ab initio, the current status quo will prevail, which will effectively sound the death knell to any prospect of opposing the DA application. And then paragraph 80 stresses why it's inherently urgent. Again, the urgency is based not on him not being able to put groceries on the table for his kids or pay the school fees, but because he doesn't want to have his opposition to the High Court application rendered nugatory. Now, whether it would have been rendered nugatory is a debatable point, but his version is this is why he has to be before the Labour Court, in order still to keep alive his opposition to the High Court application, which is brought by whom? By the DA and by the EFF. And just to avoid any possible doubt, he emphasizes at the end of his affidavit, this is the concluding salvo in his affidavit, third last line on page 32. Approaching this court, it's the Labour Court, on a semi-urgent basis or in the normal course is therefore not a viable proposition and will leave me without adequate recourse. I need my employment status restored so that, not so that I can put groceries on the table, so that I can effectively participate and oppose the DA application set down for Tuesday, 6 June 2017. And you'll see his affidavit is signed on the 3rd of June 2017. That's why he had to bring this application before court. So he doesn't lose out the chance to oppose the High Court application. To be fair to him, what he later filed was a supplementary founding affidavit, which you'll find, milady, from page 116, where he says that the High Court application, Part A, has been dealt with by agreement, but Part B is still pending. And he says at page 117, paragraph 4, the postponement of the High Court application is by no means rendered my application less urgent. That's the Labour Court application. But then he says the purpose of this supplementary affidavit is to address the additional grounds of urgency. And then he says in paragraph 5, I submit the application remains urgent by its very nature. I occupy a senior position with ESCOM, an important state-owned enterprise that fulfills a critical public function in generating electricity to the people of South Africa. The need for legal certainty regarding my employment status is not only a matter that concerns me personally, but of considerable importance to ESCOM, who cannot appoint a new group chief executive until such time as this application. So he introduces, quite rightly, the point that this matter concerns an organ of state, discharging public powers, providing public services, spending public money. He acknowledges here, quite rightly, that this is not an ordinary private employment type matter. And then he continues again in paragraph 8 to refer to the High Court application. Now, essentially, what he's saying in his founding affidavit, and again in the supplementary affidavit, and elsewhere in his papers, and indeed in their heads of argument, is that it is important that he gets relief in the Labour Court so that the High Court application is not rendered nugatory. Presumably the fear is this, that when we come to argue the High Court application, if I can just interrupt myself for a moment, maybe, we're waiting a directive of the Deputy Judge President of the Gauteng High Court in Pretoria for the setting down of that matter. The parties' counsel are expecting that we may be allocated a date, perhaps in August, for the hearing of that matter. So his argument, his basis for coming to court, it's not the usual one where people try their luck at coming to get urgent relief from this court despite the fact that they've got the CCMA to handle unfair dismissal claims. And where they say, I have sick children and I need to keep my medical aid alive, or I may face losing my house and so on. Even there, this court is frequently unsympathetic to an applicant in those circumstances. In this sense, you have alternative remedies, and there's a long queue. One sees the piles of files in the registrar's office. One has a long queue of people contending that their matters are also pressing for family and personal financial reasons, etc. No, Mr. Molefe says he must be entitled to be heard by way of an urgent application for final relief in this matter, because it's a matter that affects the High Court application. But strangely, he and his legal team don't cite in these proceedings either the DA or the EFF. So he says, I want to still be able to oppose the High Court application brought by the DA and the EFF, because if I don't, if I just accept my latest termination, which he regards as a dismissal, then the DA and the EFF and others may say, and the judge in the High Court may say, well, we don't need to decide anything about what happened in December, January and February, because recently he's been terminated anyway, so it's become academic. So he says he's got to keep alive his opposition in the High Court application by bringing this application. Now, that we submit, quite apart from the general principle, the SCA judgment that we cited earlier, that shows that political parties that are trying to hold government organs of state and ministers and group chief executives of organs of state such as ESCOM, particularly where they're spending tens of millions of public money. Quite apart from that, the DA and the EFF have their rights to continue with the High Court litigation. He says he wants to continue to oppose that High Court litigation. So in other words, he wants to influence the result of the High Court litigation. Now he's entitled to try to oppose the High Court litigation in whatever legal and appropriate means he may deem fit. But if he's going to do it by way of bringing an application to this court, we submit that quite patently the DA and the EFF have a direct and substantial interest. Not just because they have an interest in public accountability, but also because they are litigants in a case directly against Mr. Molefe and the Minister and ESCOM. And if he's trying to influence the outcome or protect his rights in relation to the High Court application, and therefore be able to argue certain things in the High Court and to resist certain arguments in the High Court against him by bringing this application, he has to join the DA and the EFF. Even if one were to adopt a blinkered approach to standing, along the lines that our courts used to in the pre-democratic constitution days, the DA and the EFF at the very least have an substantial interest in the outcome of this matter by virtue of the 2 points. Their interest in public accountability, holding government to its obligations under the Constitution, which would include taking rational decisions, which therefore means that they can challenge on the grounds of administrative law, rationality, and constitutionality the decision purporting to reinstate Mr. Molefe. So that's the first basis, their interest in public accountability and compliance with the Constitution. And their second interest, which is of course related to the first, is the fact that they are still running litigation in the High Court, which he's opposing, which Molefe is entitled to oppose. And he's trying to either preempt or at least influence through these proceedings. And on that basis we submit, my lady, that this is a clear and obvious case where the DA and the EFF were either entitled to be joined from the beginning or at the very least have a substantial interest to come as they do in terms of Rule 22(2) and 3 of this court's rule for leave to intervene and be joined in these proceedings. In my introductory remarks, my lady, I made the point that the courts have allowed frequently political parties and civil society organizations such as Freedom Under Law, allowed such parties to bring litigation of this nature. And the courts have expressly recognized, such as in the judgment that I quoted from earlier, the importance of holding government to account, to comply with the Constitution and other legislative prescripts, the interest of the wider public in that cause, and the important role that political parties and civil society organizations play in that regard. And I would remind the court, lady, of the point I made earlier, which is that the minister herself says in her affidavit that she only became aware of the so-called early retirement agreement with the objective of the 30 million golden handshake through the High Court application that was brought by the DA and the EFF. Yes, indeed. So it is precisely through an open media and through allegations being tested and misdemeanors being challenged by political parties in court that one has the very important element of accountability being achieved in practice. Otherwise, it belongs in an oath of office when someone is sworn in by a judge of the court to become a minister, or one gets sworn in as an MP, never to be heard of again. These things can be papered over and suppressed. And so it is precisely in that context that this type of litigation was brought in the High Court, and there is a clear link between the High Court litigation and this litigation in the Labour Court, and that is precisely why the DA, we submit, has the right to be joined in these proceedings. We make the point in our heads of argument also, my lady, that this is not an unreasonable or frivolous application by the DA. It's indeed serious. That is an element of the criteria to be applied when joining a party as an intervening party. And clearly, we submit that the DA's application is indeed serious, certainly not frivolously made. These are very important issues of public importance. The reason why the media is here is because the citizens of this country are entitled to see these issues being tested inter alia through the courts, inter alia through arguments such as those that we seek to make come Thursday of this week to deal with the merits of the application, if this court is disposed to grant our application for leave to intervene. Clearly, Milady, we understand the pressures that the court is under, but self-evidently it will be necessary for a ruling to be made before Thursday, and certainly from our perspective, there doesn't seem to be any need for your ladyship to hand down a reasoned judgment immediately. Your ladyship can deal with the reasons for whatever ruling you may decide to make on this intervening application in due course, perhaps in the main judgment, because you're going to have to deal in any event with the merits in due course. Lady, may I have a moment to confer with my juniors? Thank you, Milady. Those are our submissions. We would then ask for the relief that we pray for in the intervention application, that our client be allowed to intervene, and that we can then be allowed to proceed to join in the fray on Thursday, when there'll be plenty more parties all arguing on the merits before your ladyship. Thank you, Milady.